Not actually. There we go. Okay, I am now recording. I'll let in our one person we got so far. I'll let in anybody else as we go. You're sharing your screen, so that's good. Um, all right, yeah, it's 4 o'clock. Yeah, I don't want to keep on waiting. I'll just let this person in right now, Manna. Okay, and then I'll introduce you,
Okay.
and then I'll do the little spiel here. So. All right, we are now recording and starting the presentation. Hello, everyone. Welcome to today's presentation on expungements and clean slate law. Um, Thank you for joining us today. My name is Isaiah Stagg. I am the guy behind the chair for this webinar today, making sure everything goes smoothly. And our presenter, Manna Kleiser, will be giving the presentation today, and hopefully we have some good information to share with you all. Just a quick reminder to not post any personal information in the chat. Please do not type any addresses, phone numbers, social security numbers, anything like that into the chat because these are being recorded and this will be uploaded to YouTube at a later date. So if you have to leave early for any reason, we will be sure to upload this to YouTube and share those links with you to make sure you have access to the complete thing whenever you'd like. So yeah, with that being said, again, if you have any questions that don't contain personal information, you can type those in the chat and we can either get to them at the end or as we go if I find a good spot to stop. But other than that, I will turn it over to our presenter, Manna, if you want to take it away, Manna.
Thanks, Isaiah. Yeah, hi, welcome everybody. I am a staff attorney in what we call our Economic Justice Unit, and I also do elder law, so it's a fun time to be presenting here. But what economic justice means is trying to help people kind of become more self-sustaining and empower, a pathway there. And so what fits really well in that is what we're talking about today, getting a clean slate. So I'll talk about a few things, but before I do that, I guess just a reminder of who we are here at Smurls. We are a free civil legal aid organization. We've been in organization since 1909. We serve 33 counties of southern Minnesota. And we take a ton of cases in a wide range of things. We do not take cases that will generate a fee, so like a personal injury sort of thing, or a case that a private attorney is likely to take. So to be more specific, here's kind of our wide range of services. And like I said, what we're focused on today is kind of within our benefits unit or economic justice. Um, and yeah. Okay. So what I'll walk through today, and I'll slow myself down. We're going to talk about the harm of criminal convictions. Like, why would we even talk about this topic, right? We have to figure out what harm things can cause. And then I want to walk through DHS disqualifications, which are like background study denials for healthcare jobs. And then I'll talk about criminal expungements, and then also we'll have a little bit on pardons. So, yeah, happy to answer questions as we go or at the end. Okay, so why do we do this? Why do we care about this? There can be a lot of harm associated with having a criminal record. And so, what we see a lot of is that people have a huge impact to their employment. Any job that runs a background check of really any sort could flag a criminal record and use that as a reason not to hire somebody. Um, they're also public records, so I mean, even outside of a formal background check process, it is a public record. And a lot of job applications do ask about criminal records. And so just that, to any job, it can be a barrier. It also has a big impact in anything where there's licensure, especially in the healthcare setting or even a childcare setting, where you have to do a more rigorous background check. Um, that can be an absolutely no, you cannot do this whole category of jobs. In general employment, I mean it's not that somebody couldn't hire you, it's just that when you have 10 candidates, it can make it harder to stand out. In healthcare, it's like absolutely no, you cannot have that job because of your background. And then similarly, there are some driving jobs where a bad driving record is going to have an impact on the ability to do that type of work. The other thing we see a lot of is an impact to housing. So these records do show up on rental checks. It could be something you have to list on an application to housing, and so we do see people get denied, um, housing because of this. And then, kind of more broadly, what I hear a lot of from my clients is that the just it feels like this cloud that's like hanging over you, following you everywhere, and it's just like I'm not that person anymore. I don't want this with me anymore. Like I just want it gone. I don't want, anybody I meet to potentially be like Googling me and figuring this out. And it's just not me. So it definitely has a real big impact on people. It's something people think about every single day, depending on the situation. And so it's worth, for those eligible, it's worth figuring out if there's anything we can do to alleviate that. So the first thing I want to talk about are disqualifications with DHS. And so I'm only talking about the way this works in Minnesota. So DHS is the Minnesota Department of Human Services. And they will have, it's called a disqualification, and they'll make this decision that you're disqualified. And it's normally triggered by criminal records or maltreatment records. And so maltreatment is something that's an agency decision for, abuse, neglect, exploitation of either a child or a vulnerable adult. It's not necessarily a criminal case, but it's another thing that DHS looks at. So either of those might trigger a disqualification. Somebody with a disqualification is stuck with it for a varying duration. It depends on what the thing is that triggered the disqualification. So it could be 2, 5, 7, 10, or 15 years. It could also be permanent. The most common ones I see are kind of more in that 7, 15, or permanent sort of range, depending on somebody's conduct. But there's a law, and if you read it, it tells you how long it's supposed to be disqualifying. And then what I'm talking about is just general DHS disqualifications. Specific licenses have their own additional requirements. So, um, like a nursing license or a medical, like doctor license, that has their own rules. And so something that might not be generally disqualifying still could be an issue with a specific license. And so I don't know as much about that, and that's not what I'm here to talk about. And then I talked about these time durations. So obviously permanent means permanent, but the other ones where it's not permanent, the time starts ticking not since the conviction or the act occurred, but it's actually since the discharge of the sentence. So if somebody had a conviction and then they were on probation for 2 years, the time wouldn't start until that discharge of probation. And so you might say, oh, I did something like 10 years ago, it's forever ago, but depending on when the sentence was discharged, you might still have this issue going on. So it's a long, complicated list of what is disqualifying. I don't normally like to just tell people to read the statute, but the only way to know the list of what's disqualifying is really to read the statute. Um, the but a lot of things are disqualifying. What I see a lot of are theft cases, any sort of violent case, any sort of like assault sort of case, anything like that, of varying degrees, right? It could be a misdemeanor, less than $500 shoplifting thing, and that could still be a disqualifying event. But it also could, like I'm pretty sure every felony is going to be disqualifying. So it's complicated. And then the other thing to note, which is so unique to this situation, is criminal records, even if there was no conviction, can still cause a disqualification. So it could be that somebody was charged with a crime, that case was dismissed, they have no criminal conviction, but DHS still looks at the underlying records of the case and says, actually, we think you did this, and so we're going to disqualify you from jobs. And so that is something we see as well. Um, and there's an appeal process for it that I will talk about.
There actually is a, question
Oh,
on this too, Manna. Yeah. One of our listeners is asking, how does compassionate release count towards discharge? So if they're discharged early for compassionate release.
Yeah, it's exactly the date that the sentence is discharged. So compassionate release should be it would move up that date. And in somebody's record it'll have like the actual it'll say discharge of probation or discharge of sentence and it'll have a date. So whatever that is in the paperwork is going to be what they use.
Hmm. And compassionate release usually moves up that timeline by a decent margin. So,
Yeah.
okay.
Okay. So for somebody with a DHS disqualification, what does that mean? It's going to apply to any job that requires a DHS background study. And so what we see a lot of are PCA jobs, nursing assistants, childcare workers, and more. A PCA too could be somebody that, doesn't necessarily think that they're going to be a PCA, which stands for personal care aide, or assistant. I don't know what the A is actually. Something. A helper. Um, it could be that you don't think that that's what you're kind of setting out for, but now you have a family member that's in need of in-home care, and you're trying to get lined up to be that caregiver, and all of a sudden you have this issue, and now it's like, well, it's a hard situation because you're trying to provide the care. You're probably doing the care. It's just that they don't want to pay you for it because you have this thing on your record. So we see it a lot. The letter that says that you're disqualified will say what the restrictions are. And again, that can kind of vary. Normally, what the restriction is that you're not allowed to do any direct care with either children or vulnerable adults or both. Sometimes there will be you can do some things and then it's up to your employer if they want to like jump through that hoop with you. And employers are different on how much patience they have with something like this. And so for people that already have a job and then they get this, they'll have to leave the job and be fired. Um, if they, or it'll be triggered when you're applying for a job and they ask you to do a background study as part of the application process. Okay, so if this happens, there are some options. So the very first time DHS reviews your records and says that you have a disqualification, you have this ability to challenge the correctness. Um, And the argument is that I didn't do this thing that you're saying is disqualifying me. So if it's a criminal conviction that's triggering a disqualification, that's not an argument that's going to work because you were convicted. But if it's either like a maltreatment finding where you're saying I didn't do it, or I didn't, I there's arguments you can make about maltreatment, or if they're doing this preponderance of the evidence finding where you did not get convicted of a crime, but DHS still thinks there's enough evidence that you're disqualified, you can challenge the correctness. And it's a 30-day window to appeal. It's a very, very strict deadline. There's no good cause to do that late. But then that provides a pathway to have a hearing on the issue. The other option is called a set aside. Anytime you're disqualified from a job, you have 30 days and you can request a set aside. And the argument here is I did the thing that's causing this disqualification, but I don't pose a risk of harm. And it's specific to each job. Um, so if you got fired because of it and the employer doesn't want you back, it's not super helpful, but it's still somewhat helpful to get a set aside. But if it's a situation where the job is waiting for you, or it's like you're trying to be a PCA for somebody you know, and obviously they want it to be you, it makes sense to do this set aside request. And it's on you to say that I'm not a risk. I don't pose a risk of harm to other people, especially in this program where I'm working. And there's several factors that DHS is going to weigh um, and decide if they agree. And then if it's granted, you're still disqualified, but it's set aside. And so you're still allowed to work in the job that, caused that you're trying to work in. But then if you have a second job, you'd have to do it all over again. And the factors, I'm not going to talk about yet because the factors are really, really similar to the criminal expungement factors. And it's like I'm a better person than I was when this bad thing happened. I've rehabilitated. I've taken accountability. I've moved on with my life. So, stuff like that is what they're looking to see. So that's all I've got on DHS disqualifications. I'm going to move on now to criminal expungements, where I think is where we're going to spend the meat of today. And criminal expungements, there's a few ways to go about it, and I'll talk about all of them. There's prosecutor-led expungements. There's automatic expungements, which are pretty new. And then there are petitions for expungement. So here at Smurls, if we're helping a client, it's pretty much always going to be this petition for expungement, um, which you would do if the other two options, don't work. So with that, the first way to get an expungement is, and maybe I should just back up. An expungement is you have a criminal record, an actual conviction, and you're asking for it to be sealed, hidden, not showing up to the public anymore, is what an expungement is. So you're saying, I want this gone, kind of like what we talked about earlier, clean slate. This isn't me. Okay, so the first way to do it is it's called a prosecutor-led, and it literally is you're asking the prosecutor involved in your case to just agree that you should have an expungement. Um, the Attorney General's office has a statewide program to help people do this. Um, and then some counties have their own programs as well. But I think at the helpsealmyrecord.org, it kind of walks you through your options once you put in your information. And so the way it works is you're just asking. And obviously, prosecutors want to see something of why they should do that because it's their time and energy. Okay, sorry, Kat. Um, and so the Attorney General's office has this form that you fill out that you kind of tell your story of why you want this, why you need it. Um, and then they connect with you and then they try to help reach out to the prosecutor's office. So some limitations on this. It has to be an eligible conviction, so it has to be something that if you wanted to, you could petition for expungement and you just want to see if you can do this route instead. So not every criminal conviction is eligible for a prosecutor-led expungement. And then the other big issue is that a lot of prosecutors just won't respond or won't agree. And so you can ask, and it doesn't hurt to ask, but then if they don't say anything, there's no like right to make them respond to you. The new thing that we have now is automatic expungements. And so this is actually part of the Clean Slate Act, which was passed in 2023. It became effective, I was going to say this year, but it was last year, January 1st, 2025. It actually took a little bit longer than that. It was supposed to be effective in January, but it took them a few months to really start doing it. But now it's pretty like they're moving. We're seeing actual people get automatic expungements. And so what happens, the way it works is the Bureau of Criminal Apprehension is a statewide agency that holds all the criminal records for the state. Um, and they go through and they look under this new law if anything is fits within an automatic expungement. Then they reach out to the court to try to get it automatically expunged, and then the court will either do it or not. Um, the court is supposed to do it if it's eligible, but I'll talk more about it. The what is eligible to be automatically expunged is a limited list. So dismissed charges could be expunged. There's a 1 year waiting period. And when I say waiting period here, and I think everywhere, it's the waiting is when the discharge of the sentence went in. So not the conviction or the act, but the discharge of the sentence. For petty misdemeanors, all petty misdemeanors except for traffic violations can be automatically expunged. There's a 2 year waiting period for that. It's a lot of misdemeanors, but not all. So it's only some misdemeanors and some gross misdemeanors. There's either a 2 or a 3 year waiting period. In the clean slate law, it says, it's all misdemeanors except, and then there's a limited list of, what is not included. Um, and those tend to be domestic violence related or something a little bit more violent. Um, Same with gross misdemeanors. And then there are some felonies. It's pretty few, but there are some felonies that are automatically expunged. Fifth degree controlled substance is a 4-year waiting period, and then anything else that's a felony that's eligible is a 5-year waiting period. There's also a lot of reform on cannabis related offenses, and that also has an automatic expungement process. Okay, so it's great and it's fun, and we're seeing like it really work. But we have been noticing a couple drawbacks. So it's not a perfect system. The big thing is that when a record is automatically expunged, it's only expunged within the court system. It's not expunged to the agencies of DHS, which is who we talked about earlier, where they're going to use criminal records and then create these disqualifications. And it also doesn't apply to the Department of Health. So if you need to do a background check that involves either of those agencies, they're still going to see the criminal convictions or records, even if they were automatically expunged. The other drawback we have seen is that only the Bureau of Criminal Apprehension can do this, and there are some really minor cases that are so minor they don't go to the Bureau of Criminal Apprehension. So they don't know that you have it, and then they don't flag it to be expunged. So those typically are going to be something not as serious and hopefully aren't causing a lot of harm, but certainly it could. Um, and then a big area where there's issues is it does not apply when cases are deemed down. So it could be that somebody's charged with a felony, but then they take a plea deal and they get convicted of something smaller, like a misdemeanor or a gross misdemeanor. And so when you do that change, there's not a way for the BCA to trigger that this should be automatically expunged. And so those just aren't eligible. And then cases where there's a lot of charges or just multiple, which is like a lot of cases, a bunch of stuff gets charged and then only some gets convicted and some gets dismissed, where you have a mix, that's also not being automatically expunged because there's a mix. And so the BCA is doing it by conviction, but the court system works by case number. And so it just doesn't match perfectly. But it is something we're kind of monitoring. So could be, but it is fun for those that it works for. So anything else? Um, you've asked the prosecutor, they said no. Maybe your conviction is not something that could be automatically expunged, or maybe you need a DHS background check and you would like an expungement to make that process easier. Then the option is to do a petition for criminal expungement. Not everything is eligible to be petitioned for a criminal expungement, but a lot is. So all petty misdemeanors, misdemeanors, and gross misdemeanors, all of them, you can ask for an expungement. They have a waiting period, either 2 or 3 years. And so if you had something that is not eligible for automatic expungement because it's on the like list where it's, all misdemeanors except for these 5 things. Maybe you're one of those. You could still do a petition for expungement. And then there are some felonies that you can ask for an expungement for. It's a limited list. If you'd like to read the whole list, I have set the statute there, where it just lists out all the felonies that you could ask for an expungement on. The common ones that I guess I've seen or worked on are drug possession cases, burglary, theft of $5,000 or less, or financial transaction card fraud. It's not going to be um, really violent things, like murder and stuff like that is not on there. Um, It's, but there is a list of felonies and you could look at it. And that's what we do if people call for help and they want to know if they're eligible. We'll go through it and look and try to figure it out. Okay. So first we've decided, okay, we have something where we could do an expungement for it. Now we have to figure out, can we actually do it? Are we allowed to ask yet? Because everything has a waiting period. And the waiting period doesn't start until after the discharge of the sentence. But also, there can't be any new convictions during that period. And so, what it boils down to is you have to have enough crime-free years after the discharge of your sentence and before you petition for expungement. And they have to be consecutive. It can't be I did 2 years and then I had a different thing and then I had another 2 years, but I need to wait 3 years. Like it has to be the 3 years all in a row. And so I do have a little example. Sally was convicted of a felony on July 1st, 2015. She was sentenced to 2 years of probation. Then she had some probation violations, and she didn't end up getting discharged from probation until September 1st, 2018. And then on February 1st, 2022, she was convicted of a misdemeanor. When is she eligible to petition for expungement? I'll pause for the thinking. A felony, we're just going to assume it's one of the ones you're allowed to ask for an expungement on. And those always have a 5 year waiting period. So she has to wait 5 years. She was discharged from probation in 2018, but she didn't make it 5 years because then she got this new conviction. So now we have to start over and we have to do 5 years from then. My mistake. It's 4 years. 4 years, 4 years, 4 years, everybody. So she's not eligible until 4 years from this new misdemeanor conviction, which is February 1st of 2026. So even though this is a case that's, over 10 years old, um, and you think I have a 4 year wait period, it really is a long time. So sometimes we just have to do the math.
And actually, man, we do have another question
Okay.
in the chat. Yeah, the question is, what was the website you mentioned that had instructions for what to send to the prosecutor?
Yeah, it's called helpsealmyrecord.org. It's run by the Minnesota Attorney General's office. Helpsealmyrecord.org.
I will put that in the chat.
Thanks, Isaiah. Okay, so we have a thing that we want expunged. It's something we're allowed to ask for an expungement on, and we've waited long enough. Now what? And I always tell people you're allowed to ask, but it's not your right to get an expungement. And so it's not like you just fill out a form and this works. This takes work. Um, and that's what the courts want to see, that people are being really thorough and they really, are taking this process very seriously. So the way it works is you have to draft a notice of hearing and a petition for expungement and a proposed order. And I know that sounds like a lot, but the court does have fillable forms where it's like a worksheet you just fill out. They ask all the questions. Um, and that, you can use that and it's pretty good. We do help people that are eligible for our services with these as well. And other agencies do too. So, and there's a lot of volunteer lawyers that are interested in helping people with issues like this. So there is help available. But the way it works is you have to draft all these documents, then you have to serve it and keep proof that you did that. So, like I said earlier, automatic expungements, the Department of Health and Human Services can still see them. So if you want your record expunged so that they can't see it anymore, you have to serve your petition for expungement on them. And so normally where we're sending them is the Bureau of Criminal Apprehension, because that's the statewide agency that holds all criminal records. Also the Attorney General's office, the Department of Corrections, particularly if somebody was in jail or prison. And then the agencies, the Department of Health and the Department of Human Services, and also any relevant law enforcement or prosecutor's office that was involved with the case. So you're going to do all that, and then you're going to file everything with the district court where the case happened. So it's not going to be where you live necessarily, it's going to be where you were convicted. And everything has to get filed there. The notice and the petition and the proposed order, all of that, and then proof that you served that to all the agencies. And then you either are going to pay a fee or you're going to request a fee waiver based on your income. If people are lower income, you can get a fee waiver where this shouldn't cost any money. Then the court will schedule a hearing. The hearing cannot be within 60 days of when you filed your case. So it'll be at least 60 days later. You'll have a hearing scheduled by the court. Um, so definitely you need to attend the hearing. And at the hearing, the judge will kind of ask, about the case. They might have questions for you. They will have read everything. And then typically the judge is going to make a decision. Once the hearing is over, if the expungement is granted, it doesn't go into effect for another 60 days. So these two 60-day windows are to allow ample time for anybody in the world that wants to object to you getting an expungement. They have time to do that. And so that's why you have to serve all these people. Um, Typically, like if there's a victim in the case, the prosecutor's office is going to try to get in touch with the victim and see if they have an opinion. Um, some prosecutors will object and say, I don't think this person should have an expungement. Sometimes they'll show up at the hearing and try to make that argument. And sometimes none of that happens, and it's just like you just wait and then you go to a hearing and then that's it. But it does take a long time. So it's not a great fix for like I got denied this apartment that I really want. I want an expungement. Like it's not going to be that fast. This whole process takes about 4 to 6 months by the time you prep everything and serve it and wait your waiting periods, do your hearing. It takes a while. But after that, you could apply to a different place and then hopefully get that one. Okay, so I want to talk about the petition because that's the most important document in the case. So the statute tells you what needs to be in it. The court has also created a fillable form that they know meets all those requirements because they made the form and they know the law. But it is burdensome and tedious. So one of the things you have to do is list every single address you've lived at since the date of your offense. That's hard. Sometimes people move a lot. And it can just be hard to remember everything. One tip I have is that you can run your own credit check, and that often has your addresses. But that can be one thing. The other thing you have to do is you have to list your full criminal record in Minnesota or elsewhere. So if you have any convictions in any other state or any federal offenses, it all has to be listed. They want to know your full criminal record, and it impacts, overall looking at you as a picture, but also whether you're eligible yet, if you've waited the waiting period or not. And then it's on you to prove that you are deserving. And so the standard the court uses is clear and convincing evidence, um, which is a lot. It's not beyond a reasonable doubt, but it's up there. You have to establish in a really convincing way that you are deserving. You have to say that the expungement and the benefit to me outweighs any other disadvantages. And so the court is considering disadvantages to the public and public safety. We have public criminal records so that the public can, I don't know, Google and feel safe. And so that is a burden, I guess. And also that they're cognizant, like, especially if you're asking for an expungement because you want to go work a healthcare job, um, you know, does that make sense to the court? Are you deserving of that? And then also the burden of having to just do the paperwork of actually enforcing the expungement order. So the way you do that is kind of these three areas. They want to know what happened in your crime that you got convicted for and that you're asking for expungement for. It is not a place to say, oh, I had bad advice from my defense attorney and I pled guilty to this, but I didn't actually do it. That does not get you anywhere. What the court wants to see um, is that you're kind of acknowledging your own wrongdoing, you're taking accountability for your own actions, but you're saying, but I've moved on. This isn't me anymore. Um, and I'm not saying that people don't have really valid complaints about what happened in their criminal case, but to a judge, they're going to say, we're not hearing that issue right now. We're hearing whether you should get an expungement. And so part of what you have to do is take accountability for the crime. Um, Then they want to see why the expungement is needed. What kind of harm are you facing because this record has been following you around? Have you lost jobs? Have you been denied housing? Do you have any letters of support showing that, like a denial letter, especially if it, some of the, depending on the program, like some denial letters will say it's because of this. That's super helpful to show the court that it's not just your perception, it's like something tangible that they can look at. And then, why are you deserving is kind of the next area or the bucket that they want to look at. What are your steps of rehabilitation since the offense? Um, and that's going to look different for everybody. Are there particular areas of personal growth that you can talk about? Um, one thing I've heard from multiple clients is kind of like, I was young and dumb, but then I became a parent, and that really like reshapes your perception on the world, and like that's not who you want to be anymore. Um, maybe got a different friend group and stopped making bad choices. Maybe you got connected like in a spiritual or religious way and it has changed you. The other thing that they want to know about is sobriety. So particularly if drugs or alcohol were part of your offense, even if it's not a drug or alcohol crime, but if it's like I was shoplifting all the time to fund my drug addiction. That's really helpful to know. And are you sober now? And how long have you been sober? And tell us more about that. It's kind of a place to just lay it all out there and be a little bit vulnerable, which can be hard. And I definitely get that. But, a letter of support from something like a sponsor or a treatment facility that you've been to is huge in these cases. The other thing that I see a lot of is mental health treatment. Maybe you were acting all sorts of ways, and then you have now discovered that, oh, that's like a mental health problem I have, and now I'm connected with treatment and I can manage my behavior better. Um, anything about that is really helpful. Letters of support are really nice to have. It's not required, but if people can get them, I think it's really useful. And it doesn't have to be like huge. It could be from a really good friend you have that can speak to your character and your growth. It could be from a boss. It could be from, I think I had one from somebody's daughter once of like, when I was little, that was a bad mom, and now she's different, and now she's a grandma, and I like, they've kind of mended relationships. Victims, if there's a victim in the case and they're supportive of an expungement, that goes a huge way. And then if you've done anything that shows rehabilitation, like a certificate of completion, some sort of programming, right? Like anger management or mental health treatment or rehab or anything like that, I would submit it. There's no limit to what you can submit. Okay. And then what do the courts really look at? So that's kind of like how you tell your story, but it's kind of good to know behind the scenes, the court is weighing all these factors, and no one factor is like make or break the case. But this is what they're thinking about. So the nature and severity of the underlying crime. Was this shoplifting from Walmart for something that was $10, or was this like an extremely violent assault? That's something that they care about. The risk that you pose to society right now is what they're thinking about. What is your risk right now? And so that's why it's really important to show who you are right now. The length of time since the crime occurred, um, that's a big one. I think particularly the more crime-free years they can see in your record, the better. Um, and then the steps you've taken towards rehabilitation. Any aggravating or mitigating factors that relate to the crime. Sometimes there might not be any, um, and sometimes there might be. Like, I was in the back seat and my dumb friends did this dumb thing and I got charged with it too. It's still taking accountability, like you shouldn't have been there, but that's a mitigating factor that it wasn't your idea necessarily. And then the reasons that you need an expungement. So I have seen sometimes when the court says, that's all great, but you don't need this, so why would we give it to you? So you do have to say why you need an expungement. And so tying something to employment, housing, or other concerns you have about why this record is holding you back. And then your overall criminal record. Um, are you somebody with like a giant record and you only want an expungement of one thing? Like, does that really help you? I don't know. It's something the court's going to consider. Your record of employment and community involvement. The employment one always bothers me because it's like maybe I could be better employed if I didn't have this record, right? It's like a catch-22. But kind of like a good faith attempt of like you're trying to be connected with your community. How are you doing that? It does not need to be like I'm volunteering every week at a food shelf and I'm doing all this stuff. It could be, you're a really good parent and you want to be connected with the other parents at your kid's school and you say hi. Like, like it doesn't need to be like this whole big thing. Um, any recommendations of law enforcement or prosecutors, if they do file something, the court is going to weigh that. If a prosecutor says, yeah, I don't disagree with this expungement, that goes a huge way. If a prosecutor writes a 30-page memo about how they remember your case and it was the worst ever and they really don't think you're deserving of an expungement, that's going to make a case really hard. And then similar to any victim of the crime, the court definitely will consider that. And then whether there's restitution outstanding. Um, Fines may be an issue too, but restitution is a big one. They do not want you to get an expungement and then not have to pay your victim back for whatever the crime is that you did. But they might be a little more forgiving if you're low income and have these just like court fines associated. And then just briefly, I was only talking about adult criminal records. There's a really similar process for juvenile records. They're called delinquency records. Um, and so it's really similar. Any delinquency record is eligible for expungement. There's no wait period, and the rules, it's a really similar process, just a different statute. Okay, and then, okay, we've gone through everything. You have this disqualification, maybe. You went through the expungements. You're not eligible. You can ask for a pardon. And that is like, you can ask for a pardon for any criminal conviction. It has to be a conviction, and it can't be a dismissed case. But it makes sense to ask for a pardon if you can't get an expungement. A pardon takes forever, much longer. I have two right now. I've been waiting over a year. We're right around a year for a hearing, and there's no hearing even scheduled. So it's not fast. But it is a good option to know about. So it used to be that in Minnesota it was extremely difficult to get a pardon. That process has been revamped. We now have this Clemency Review Commission where they review pardon applications. Um, and the way it works is you apply and then you get scheduled for a hearing in front of the Clemency Review Commission. And you have a hearing with them. That's the big wait right now. It's pretty bottlenecked where, it's going to take a year or maybe longer to actually get a hearing. But then you have a hearing in front of this commission. It's like up to 9 people that might be kind of sitting in a room wanting to hear from you. And then they'll make a recommendation on whether you should get a pardon or not. Then that gets sent to the pardon board, and the pardon board will meet a couple times a year to review the commission's recommendation and then issue a final decision. So it's a really interesting area um, where you will see how things go. It's been pretty reassuring that people really are getting these pardons. It's the same process for clemency. So for people that are incarcerated and are looking for their sentence to be reduced, it's the same process. And you can ask for a pardon of any Minnesota conviction. You're supposed to wait 5 years, but you can ask for the 5-year wait period to be waived. If you have like a reason. And it seems pretty low what the reason has to be. You also can ask for a ton of stuff to get pardoned at the same time. So it could be that you have 10 things you'd like a pardon on, and you can do one application and the board can review the whole thing at the same time, which is pretty slick. With criminal expungements, it's one case at a time. So I guess I didn't say that, but keep that in mind. Um, yeah. Okay. So I've reached the end. I'm happy to stay and chat if people have questions. I think that this is such a great topic that doesn't feel like it relates to older adults, but it really does because one, it could be an older adult that wants this help, and it also impacts the workforce serving older adults quite a bit. And I'm not saying that, everybody with a criminal conviction should just be able to just get rid of it. That's not what we're saying at all. But, if you believe in restorative justice and rehabilitation and all of those things, there's a lot of people that could be doing really great work and are deserving of doing that. And there's a process in place. So,
Yeah.
yeah.
I think it's something like 1 in 5 Minnesotans have a criminal record, so it is certainly an issue that's not going to go away anytime soon, unfortunately. And there's plenty of
Yeah.
folks out there, yeah, where this information could be helpful. So yeah, thanks, man. That was fantastic. Yeah, we will certainly hang around here for another minute or two. If anybody has any questions, any general questions, you can certainly type them in the chat. And then yes, we do have our contact information here and in the PowerPoint as well. I'll get those slides sent out in the future. But yes, if you have specific questions that are more, tied to, your individual needs, I would definitely recommend calling our intake line, and you can share those details with our staff at that point. But any general questions, you are welcome to type in the chat now. Otherwise, you are free to head out now. We are all finished for the day. But in the meantime, we will see if anybody has any more questions. We have a thank you in the chat. Thanks, Manna.
Oh, thanks, guys.
Give it one more minute here. Oh no, actually, yep, yep, everyone's gone. All right, sweet. I will go
Okay.
ahead
Thanks,
and
Isaiah.
end the presentation, Manna. So yeah, thank you so much.
Bye.
And ending it.